ICTY, defending tonnage. He's also defended cases in front of the ICTR. And his most recent case in front of the ICTY was as amicus curiae for Milosevic. So he comes to this table with a really significant background and knowledge in defending individuals accused of genocide. He's going to speak about some of the characteristics of the genocide cases from a defense perspective, and particularly as to some of the issues of specific intent, which the panel of the prosecutors talked about first. So I'm going to hand this over, Misha, to you, Ryan.
Thank you, Mark. I'm very privileged to be here, and I'm very grateful to have the opportunity to participate in this conference to speak. For the record, today, only 14 times a reference has been made to defense counsel. Isn't that very typical for the position in which defense counsel is? Reality is that in many criminal cases, the public does not consider defending individuals accused of having committed crimes, that is, the criminals, as a noble profession. When defending individuals accused of a genocide, the challenges are even worse. Those familiar with the criminal justice system, however, appreciate that we do not defend the act for which the accused person is prosecuted for, but we do defend the individual. And therefore we also defend the principles of a fair trial of the society of which he is a part of. So defending, after all, is not that onerous as people may say. And we could have been mentioned a little bit more than only 14 times today. Now, what are the challenges when defending a genocide case? Let me briefly list some, and then I will go into a few of them. We are dealing with international trials rather than national trials. So we deal with procedures we are not familiar with. We deal with different practices we are not familiar with. And the crime scene is always somewhere else, abroad, in the troubled area. Very difficult to access, and there's always a problem in approaching people and to find documents. We'll come to that later. We also deal with high probable trials. These are not trials around the block. These are trials with mass media attention. And therefore, defending an accused person in these type of trials, you have to deal with publicity. And that is another skill than defending an accused person. We also deal with a high political factor. This is not an ordinary manslaughter for what reason it may have happened. Here there's always the political factor. And we deal with high-profile defendants. And on top of that, we deal with another language. At least some of us, at least me. The language is also a problem for everyone. Because, for example, take the Rwanda tribunal. If you would ask a question to a witness in English, it will be translated from English into French, French into Kinyarwanda, the local language, Kinyarwanda back to French, French to English, and it hits your ear again. And you may experience that you ask something and you hear it translating, and then you hear an answer in a language you don't understand. That will take about 1.5 minutes. And then the translation comes back, and the translation says, the witness says yes. And that's all you get. So you lose a lot on the language. We all lose on the language. Now take, for example, another challenge. which is, let's say, not really unique. It's a challenge defense lawyers always have to face. Let's take, for example, the principle of innocence. The legal theory is clear. All of us here in the room, we do understand what it means, and we try to live by it. But in reality, the practice is totally different. The presumption of innocence is, in most cases, given a kind of lip service that it sounds right, but in practice it doesn't work right. It has a large damaging effect on the trial when the publicity is not observing this principle either. The accused person is pictured everywhere as if he has done it. And in genocide cases, it's even worse. So we have to take into account a few difficulties. One of them is the presumption of innocence is a legal concept, but not a concept for the public out there. And you will find in the courtroom that it reflects to the participants there as well, for the prosecutors and for some of the judges. Now, I may remind you, and we'll come to that later, that we deal here with people who may be a crook in the courtroom. You see, I forget about the presumption of innocence as well. But at home, for some of these people, they are heroes. So we deal with a split personality issue. Are they heroes? At home, yes, they may be. Are they crooks? Yes, in the courtroom they are. And as a defense lawyer, you have to find your way through it. Now, defense counsel may be appalled by the public because the question always is, why on earth would you defend such a monster, if I would emphasize the wording of David Crane? Why would you defend a monster because he should be prosecuted and tried, and perhaps even the phrase would be hang him first and try him later? Now, let's get serious. What are the specific challenges when defending individuals accused of genocide? For the purpose of the presentation, I have clustered two issues: the law and the person, the substantive law and the person of the accused. As far as substantive law is involved, defense counsel are always keen to interpret the test to be applied. Of course, there are two ways. One is to narrow the test as much as you can, hoping that your client will not fall within the test. Or the other one is to create some kind of room to maneuver. So you will argue that your client, on the face of it, may be in the test, but effectively he doesn't copy the test. Or as the lawyer of O.J. Simpson said, if it doesn't fit, quit. So the paramount test in all genocide cases is always the test of special intent. We heard a lot of it this afternoon. And the issue may be this. The test has, as we all know, two components: knowledge and intent. As far as the component of knowledge is involved, there is little or nothing to do for us defense lawyers. It's quite a simple test. It's more or less driven by evidence, not by interpretation. Because the theory is extremely clear on the issue. It's not only knowledge, but also awareness of circumstances that exist or consequences that may occur in the normal course of offense. The first one is we are dealing here usually with very powerful people. And we deal with people who have strong opinions, and there's always the ethical issue. him belonging to one group and the victims belonging to the other group. Mostly an ethical issue, but it may also be on the other side of a difference. Now, having that in mind, defense lawyers will have to face specific problems when dealing with these kind of people. Because the theory has it that you are instructed by the client, but the practice here is you have to accommodate with your client. You have to find common ground and to find a kind of compromise how to approach the case. On a number of issues, for example, on strategy, on selection of witnesses or how to deal with witnesses, and most importantly, how to fit in the politics. Clients will usually want you to put in every politic issue he has to say, and you as a defense lawyer know exactly what he shouldn't and what will ruin his case. So there again, you will have to find a common ground. Now, let me conclude by saying this. Defending an accused person, whether it is genocide or any other crime, actually comes down to one thing. And that is, you have to perform your function as defense counsel in an objective way, in an independent way, in a very impartial way. And by doing so, you have to do it in a decent way. You have to be effective for your client. You have to do the best you can offer him. And at the same time, you have to be loyal to the legal system in which you function. Because after all, people will understand you've done a decent job and an honorable job when you act along these lines. Thank you.
One of the issues I hope we get into questions and answers, of course, Misha was in a unique situation of being assigned by the court to look after the interest of Slobodan Milosevic, and yet Slobodan Milosevic, of course, had determined he did not want counsel. And so how do you go about looking at the interest of a client, not even your client, and when defending genocide, and in the interest of the court to ensure that the defendant's rights are in fact protected? Stewart Alford is an English barrister, again a very prominent individual in the English bar. He was, in fact, a prosecutor at the Special Court for Serious Crimes in East Timor. He's also part of the UK delegation of the Rome Statute. And on the defense side, he's been exceedingly active with the International Bar Association's program in providing training for the special tribunal, both the judges and the prosecutors, and also in the defense attorneys in the Cambodian tribunal as well. So, Stuart, we're delighted to have you here. He's going to talk a bit about this relationship that came up earlier in the panel discussions this morning about genocide and crimes against humanity, and particularly from the perspective of the victims. So, Stuart, thank you.
Love is an ideal, and marriage is a reality. And it's important that we don't confuse the two. The Convention to Prevent and to Punish Genocide is an expression of a reality, is an expression of an ideal. The efforts of courts and tribunals to punish are the reality. And here we're talking about the realities of staging trials to punish those suspected of genocide. Now, of all those realities, to the person who is on trial, the reality is perhaps sharpest of all. To be successful, a marriage has rules. Those rules may differ between marriages. That's what makes some successful, no doubt, and some not. The punishment of genocide, so the second limb of the Convention's title, also has rules we've given it rules. Those are the rules that lawyers describe as the rule of law. The rules themselves are embodied in a series of different ideals, recognised at an international level. Rules of legality, the fair trial process, expressed perhaps most comprehensively in the International Covenant on Civil and Political Rights, perhaps the single document that contains within it what we collectively express as the ideal of fair trial and legality. The Convention on Genocide doesn't contain within it, of course, any of the rules by which we are going to punish. It simply sets as an ideal that we shall. It gives two options, doesn't it? One, to punish nationally, or secondly, to punish internationally, at that time in a court unknown. Now, no doubt under national systems, the punishment will follow the rules within that national system. And as we know from Iraq, as we were hearing earlier today, there were efforts to try and adapt the national system to fit more closely with some of the expectations that were held internationally before the trials themselves were staged. At an international level, of course, the rules are not laid down in the Convention, and they are not laid down anywhere else as a set of rules that can be followed by the courts. And so the courts themselves have had to work through and untangle some of the issues. From a defence point of view, this might create some problems. Because although it's a burden for everybody, of course, to work in a situation where the rules are not settled, a fundamental principle, one that Misha touched upon, would say that those issues which are unsettled should be resolved to the accused's favour. I wonder, if we look back on some of the decisions of the courts that we have seen, we can always say that has happened. One of the legal tangles that has had to be unravelled by courts is between genocide and crimes against humanity. And we know, of course, that jurisprudence has now laid down quite clear definitions developed to identify the various elements we've talked about throughout today. But that overlap and proximity, which Bill Shabba started discussing this morning, but which has continued through a number of our panels during this afternoon, has to some extent, of course, been eroded. It's been eroded by the developments since 1948 that has seen the distinctions between genocide and crimes against humanity largely disappear. There have been judgments which have considered the multiple convictions of individuals for sets of circumstances which may be covered by either definition, genocide or crimes against humanity, the ICTY, ICTR. There have been plenty of decisions which have considered that very issue, resolving that multiple convictions are permitted where an offence carries, or each form of offence carries a materially distinct element. But the point that's come up consistently through today, which has not yet had a defence voice to it, is whether it matters from a defence point of view. We've heard, of course, whether it matters from an international point of view, and João Mendes identified a number of very persuasive arguments why it does matter on an international level, because if labelled genocide, by his experience, one gets a different reaction, whether it's down at the UN or elsewhere, if on a scale which he described in terms of the Holocaust in Rwanda, it can be said to be a genocide. From the international community's point of view, therefore, we have discussed this. We've discussed it also from the community's point of view, in the last session with the prosecutors about whether it matters to the communities themselves whether this thing is described as a genocide or crimes against humanity. It probably doesn't matter much from the media's point of view, because we know the media will call it war crimes, whatever. It might call it genocide if it can get that into the title. What we know is they'll never call it crimes against humanity. Who has ever seen the title in any publication which contains the phrase crimes against humanity? Presumably it's just not snappy enough. But from a defence point of view, there must be, mustn't there, some consideration given to whether genocide or crimes against humanity matters. A lot of that may rest upon the very stigma that the expression carries. To be labelled a genocidaire must matter. It may not matter to your sentence, or so we might think, if we look to the international instruments, to the sentences that are prescribed there, because, as we know, the sentence for genocide and crimes against humanity is essentially the same. But one wonders whether that will be the case if, in the future, we see the continuation of the development of domestic systems taking over much of the prosecution. Because in a domestic setting, one can imagine more clearly that there may be a distinction made between genocide and crimes against humanity, if this relative position of the two crimes is to be maintained. And of course, from Iraq, from the recent experience of this year, we can see just how that may matter. Because if the trend towards domestic prosecutions is going to continue, and if countries are to be encouraged to deal with their own prosecutions, we take the consequence of the systems that they employ. And systems like Iraq, which carry with them the death penalty, may include within them the possibility that the distinction between genocide and crimes against humanity may have a very real bearing upon the way the court acts. Because if we are going to grade this offence, genocide as against crimes against humanity, so the sentence may make some difference. In systems where there is the death penalty, it may make a very great difference how someone is convicted. This isn't, I would suggest, an experiment in stretching the definition of genocide. We've heard quite a lot during the other panels and the other sessions about the opportunities to develop, perhaps to prosecute at the edge of the envelope. I think that was Robert's particular expression, a way of putting it. But from a defence point of view, the suggestion that this is an opportunity to try and move the boundaries of our understanding of the offence, that has a very real bearing upon the individuals who face the court. In pursuing the ideal, which is the punishment of genocide, it's important, isn't it, to look to our other ideals, and amongst those, the ideals of legality and fair trial, and see that we don't compromise those ideals in pursuit of the realities of our trials.
Sure, thank you very much. I'm now going to ask for Nick Stewart to continue this discussion. Nick, again, is, as with Stewart, is an English barrister. He's a QC. Again, a very distinguished barrister in England, but uniquely qualified for this panel because he defended Krajisnik, and he successfully obtained an acquittal for Mr. Krajisnik on all charges of genocide. Now, the fact is, he did get 27 years of crime but nonetheless, quite successful. He's now defending Petkovic, the general from Croatia, in a new case in front of the ICTY. So Nick, we're delighted to have you here. He's going to speak a bit about the accompanying jurisprudence that's come out of his experience in the Kreisnick case, which, again, for this panel is quite unique. Nick, thank you.
Well, thank you, Mark. Kreisnick, you can see the top line behind me is Sept. On the left is an excerpt of Milosevic. And on the right is Mr. Kreisnick. Why, following Mark's comment, do I think of the old joke that was a successful appeal, we got you off the drawing in quarter? It is true, Mr. Kreisnick was convicted on everything else, which actually was pretty much all the things we've been talking about, extermination, persecution, and all that sort of thing. We talked about love and marriage a few minutes ago. Mr. Kreisnick and I were divorced at the end of his trial. He is appealing, so I've got to be a little bit circumspect when I say I would anyway, because he was my client after all. And he is now appealing, and the prosecution are appealing. He's appealing all convictions, the prosecution are appealing the sentence. They're not appealing the acquittal on the genocide charge, which is important. That gives me a little bit more freedom on that after all. The basic outline, and I'll have to take it that though not everybody probably knows all about Yugoslavia, in fact nobody knows all about Yugoslavia, I can't give a positive history of that, or that would use up all my time and more. But it was Bosnia we were talking about, and the Serbs in Bosnia, who included Kreisnick, at late 1991 and early 1992, it became pretty clear that they and the Muslim population in Bosnia, because Bosnia was a very mixed population compared with other republics in former Yugoslavia, they were increasingly, apparently were not going to resolve their differences. War broke out at the end of March 1992 in Bosnia. And the Serbs, what they had in mind, and there isn't really any issue about this, they wanted to carve off a bit of Bosnia for themselves. And because Bosnia was described as a leopard skin, there were majority Serb areas, there were majority Muslim areas, there were majority Croat areas. The Croats were a smaller number than the Muslims and the Serbs. But they were all tangled up all over the place, and you'd have a broadly majority Serb area, but there'd be pockets of Muslims and Croats. So it's all really complicated. The only way in practice that this could happen was by what did happen, which was by, if I say wholesale movements of population, I'm talking about movements of population which were not voluntary. It happened on all sides, but to Cochrane not being a defence, as far as Mr. Kreisnick was concerned, it's what the Muslims did. The basic point is that he was very close to Karadzic. The judgment describes him and Karadzic as being the main figures in Bosnia. The prosecution allegation was always that he was number 2. And based on the findings of the trial chamber, it's hard to dispute that he was there or thereabouts. And the leader of the Republican serving the Bosnian Serb army was Mladic. So those are the 3 big figures. Of course, it's Mr. Kreisnick's misfortune at the moment. He's the only one of the 3 to have actually got, not voluntarily, but got to The Hague and been convicted. The point about genocide, I'm not going to go into elaborate analysis or any analysis really of the law of genocide. You've got intent on 2 levels. There's got to be an intent to commit the crimes on the ground, as we would call it. The murder in one example, killing is described in the statute and in the convention. There are other ways of committing genocide. That's one intent. The accused has got to have the intent to have committed those crimes. He's going to, in this particular case, it's going to have been from above, as it were, as one of the leaders. He's not actually going to be out. I don't suggest that Mr. Kreisnick was actually out killing people. But that doesn't mean he was taken very clearly to have had the necessary knowledge and intent from everything he knew about what was going on in relation to the crime on the ground. But the important level of intent, and this is where the charge was rejected, is the specific intent, the mens rea, to commit genocide, the genocidal intent. And the simple finding there was that even one sentence from page 391 of the pocket-sized judgment will slip into a problem and go home with, and that's not even at the end, they're just building up suspense at that point. But even the more extreme statements of the accused, such as his speech at the Bosnian Serb Assembly session of April, January 1993, do not enable the Chamber to conclude that his intent went further than the removal of Muslims and Croats from territories in Bosnia and Herzegovina. Now, the way in which they removed it, of course, led to conviction on the trial chamber's findings on all the other charges. Crimes against humanity, there were war crimes as well, detention camps, and so on. So, very serious charges.